Yes, Mr Peacock.
My lords, my lady, I was going to address some preliminary points which came up during this morning's submissions. The first was just to address the history. My learned friend referred to the introduction of private rental sector offers by an amendment to section 193 made by the Localism Act 2011, which then came into force in November 2012, and suggested that prior to that, the duty couldn't be brought to an end by the offer of assured short-hold tenancy accommodation. I don't think anything turns on this, but I think the accurate position, and it's reflected in the explanatory notes that my learned friend took the court to is that before the Localism Act amendments, in some circumstances, the duty could be brought to an end by the acceptance of an assured short-hold tenancy. But it could not be brought to an end by the rejection or refusal of such an offer. So the position was that the applicant could choose whether or not to accept an assured short-hold tenancy, which would bring the duty to an end. But that was their choice, and if they chose not to accept such an offer and wait until Part 6, more conventional council housing, came along, they could do so. And the explanatory notes records that the change in the legislation was made so that offers could be enforced,
yes,
and the duty brought to an end if they were refused, because that was considered a failure. The second preliminary point is my Lord and Lord Justice Nugee, I think, raised the question of whether Westminster has a procurement policy in relation to procuring temporary accommodation. It has, and it was before the court before the lower court, and my learned friend's grounds of appeal or skeleton argument made various criticisms of that procurement policy, which aren't now pursued in this court. But there is a policy. It could be made available to the court if that was helpful. But it could perhaps most conveniently be found online. It's on the Westminster Council website under Homelessness policies.
Depends how long it is, Mr Peacock.
It's not, I think it's 15 pages or so. There's a procurement.
Well, if there's no objection, as everybody's been referring to it, maybe we ought to see it. Yes.
There's a procurement policy, and there's also an action plan, an annual action plan underneath the policy.
Is it the if we did go online or get our clerks to go online, will we get whatever edition is relevant for present purposes, or doesn't it matter?
You won't get the current action plan, but I think it's fair to say that only the procurement policy itself was before the lower court, and the action plan then enforced, or any other action plan wasn't before.
Well, I think for the avoidance of doubt, would if you're offering to supply us with copies, could you have copies supplied to my clerk anyway, say by tomorrow?
Yes, would you want the copies of both the action plan and the policy? Or just the policy, which was what was before the lower court?
Let's have the one that was before the lower court. Thanks.
The third point, I think my Lord Justice Bean was asking about the document at page 38 of the supplementary document, and asking whether what it was and whether it was supplied to the applicant. My understanding is that the document at page 38 is what St Mungo's sent to the council to make the council aware that 58C Piccadilly Road is available for use as a private rented sector offer. That then leads, if one goes back to page 30 of the supplementary file, that then leads to a suitability assessment by the officer concerned, which doesn't address the requirements of Article 3, but focuses on the particular requirements of this particular household, in particular in regards to the location of the property. So that on page 31, it looks at whether it has any effect on the working commitments of the members of the household, on the education of any members of the household. At the bottom of 32, we see consideration of support networks. Halfway down 33, we see consideration of effect on professional support. 34, we then see a consideration of the local amenities, nearest railway stations and dentists and GP surgeries. And then on 36, we see a consideration of the affordability. Having conducted that assessment, that then will have led to the nomination form at page 40 of the bundle, which is where the family's details are filled in, and one can infer will then have been supplied back to St Mungo's.
So, pages 31 following are Westminster's internal document called an assessment.
Well, yes, I'm not sure what its formal title is. It's in effect, it's a suitability assessment.
Okay.
Because it, at the top of 30, it identifies the property, it then identifies the household, and it asks a series of questions. Does anyone in the household work? If they do, can they commute from this property to their place of work? Does anyone in the household, are there any school-aged children? If so, is this going to disrupt their education? Do any of them have special educational needs? What are their support networks? And
Does page 38 is 38 and 39 is St Mungo's document. Does that have an official name? What is it?
I think it's just details of a potential letting that's supplied by, I don't know what its official name is, but it's details of a potential letting that's supplied by St Mungo's. It may have been sent just to Westminster, it may even have been sent to different local authorities.
Right.
Does it, I was going to say, does it go with 40 and 41, which calls itself Availability Notice and Nomination Form, and is also a real lettings form?
Yes, I think it must do, and it may be that 38 and 39 is the availability notice, and 40 is the nomination form, and we can see Mr Hajjaj's and his family's details filled in on that form, and that obviously must have been completed by Westminster after they'd identified this particular household as the household they wanted to nominate for this particular information.
So real lettings send 38 to 41, and then Westminster send back 40 and 41 once they've identified it suitable for Mr and Mrs Hajjaj.
Yes, that's right. And then that then in due course leads to the offer letter at 85 of the main report. And we can see at 88 that the offer letter comes from the same named officer, Ms Noel, who completed the suitability assessment. And we can see from 85 that a date of the 2nd of May, at the time, 11 AM, is being put forward for the viewing of the property. And one, although it's not recorded on the file, one could infer that there must have been some communication from St Mungo's after the return of the nomination form saying this is the time they should come and review. That was what I was going to say by way of preliminary remarks. I was then going to move on to the construction of Article 3. And my learned friend advances the appeal as raising the question of construction of Article 3 of the 2012 order. And as the court has seen, by section 193, subsection 7F, an authority cannot approve a private rented sector offer unless it's satisfied that the accommodation is suitable for the applicant. Article 3 then provides that accommodation is not to be regarded as suitable if any one or more of the 10 circumstances set out in Article 3.1 apply. And my learned friend argues that as a matter of statutory construction, before an authority can approve a private rented sector offer as being suitable, it must investigate and make a reasoned decision on the applicability of each of the 10 subparagraphs. And the respondent submits that that is to misconstrue Article 3, and that the obligation on an authority before it approves a private rented sector offer must depend on the circumstances of the case. Before turning to the terms of Article 3, it's worth considering the general obligations on an authority in relation to inquiries and the provision of reasons. The scope of inquiries to be undertaken is primarily a matter for the local authority, and the court can only interfere if no reasonable authority would not have undertaken further inquiries. And the authority for that, if it's needed, is the case of Cramp, which is in the bundle at tab 2, paragraph 58. I don't think I need to take the court to it because it's well known. I think it's
sure it's well known to you, Mr. Peacock, but not to me. So let's have a look.
I can take the court to it. It's it's page 49 of the bundle. It's paragraph 58 of the report. And these were, before the Court of Appeal, there were two, I think at least two, maybe more, cases in which review decisions have been overturned in the county court on the basis that the authority should have carried out further inquiries. And what I think it was Lord Justice Brooke concluded at paragraph 58 is that in each case it was for the council to judge what inquiries were necessary, and it was susceptible to a successful challenge on a point of law if and only if a judge in the county court considered that no reasonable authority could have failed to regard as necessary the further inquiries suggested by the appellant's advisors. So,
inquiries into what question?
Well, in this particular case, it was whether or not the appellants had a priority need for housing and were vulnerable. At the risk of confusing things, Section 184 of the Housing Act 1985 places an obligation on an authority which has reason to believe that an applicant may be homeless to carry out such inquiries as are necessary to satisfy itself as to what duty is owed to the applicant. So there is a statutory duty to carry out inquiries.
Can we just look at the relevant statute? It's top of page 36 of the bundle.
187.
Yes, it's upgraded to my friend. It's 187 in the bundle. Is section 184.
Yes.
And it's if the local housing authority have reason to believe that an applicant may be homeless or threatened they shall make such inquiries as are necessary to satisfy themselves whether he's eligible for assistance that relates to immigration status, and if so, whether any duty, and if so, what duty is owed to him under the following provisions of this part. And that duty turns on questions of whether they are homeless or threatened with homelessness, whether they have a priority need, or whether they became homeless intentionally. So in a situation like that situation, where the authority is deciding whether or not someone has a priority need for housing, they are performing a statutory duty which requires them to carry out such inquiries as are necessary to satisfy themselves. And the court held that it was for the authority to judge what inquiries were necessary, subject to interference by the court if the authority decided not to make further inquiries was going to be unreasonable. There are two complicating factors. The first of all is in considering whether accommodation is suitable, there's no equivalent statutory obligation that says the authority must make such inquiries as are necessary to reach a decision as to suitability. But there is authority, and I think the case is Thomas and the London Borough of Islington, that says that the same approach to inquiries should be adopted in relation to the consideration of suitability. In other words, it's up to the authority to decide what inquiries it should undertake before reaching a decision as to suitability, and the court can intervene if it's satisfied that the authority has failed to undertake inquiries which any reasonable authority would have undertaken.
We don't have that case, do we?
No, we don't. I'm afraid, my lady. I can provide details on it. When I provide the procurement policy tomorrow.
Yes. In Cramp, did they consider the question, suppose that no inquiries are made?
Well, not expressly, but by implication, it was in 58. It was for the council to judge what inquiries were necessary. If that leaves it open to the council to judge that no inquiries were necessary on a particular issue, and that decision would then be susceptible to change if and only if it was rendered unreasonable. So it doesn't expressly address the question as to what would happen if no inquiries were made, but in my submission it's clearly covered by the ratio of the case. The other complicating factor, my learned friend referred to this, is the case of Peretti, which in some circumstances held that in some circumstances the public sector equality duty can necessitate further inquiries into whether or not an applicant has a disability. So in some circumstances where an applicant may have a disability, there may be an enhanced duty of inquiry on the local authority imposed as a result of the public sector equality duty to look more carefully into the issues surrounding the disability. That's the general law surrounding inquiries. So far as the obligation to provide reasons, there is no duty to provide reasons when accommodation is offered, and the authority for that is the case of Applicant and Brent, and that can be found.
That's common ground, isn't it? Mr. Colville accepts it.
Well, but it's important, I think, to look at the relevant paragraphs. because what the court found, it starts at page 82, it's page 165 of the bundle. And we can see at the start of paragraph 82, Mr Westgate was submitting that Brent had a duty to give reasons explaining why Mr Applicant was offered an out of London placement at the time when the offer was made. The Lord Justice Lewis in 83 says that the only statutory requirement for giving reasons is that contained in section 203, which applies to review decisions, and there's also an obligation to provide reasons in circumstances covered by what is now section 7 of the Review Procedure Regulations 2018. And in 84 he considered whether there was a room for an imposition of a common law duty of fairness to provide reasons in other circumstances, and referred back to the case of Akhter and Birmingham City Council. And then in 85 he says, in my judgment, this constitutes binding authority that in this particular statutory scheme, the duty to give reasons is contained in and constrained by the statute itself. The statutory scheme is designed so as to avoid unfairness if it's followed and applied by the later decision. So Lord Justice Lewis there concludes that there's binding authority that any obligation to give reasons is contained in and constrained by the statute itself. To the extent that my learned friend argues for any duty to give reasons that doesn't arise under the statutory provisions, and in particular the need to give reasons on a review decision, that authority, it seems to me, is fatal to any such submission, because unless he can find something in Article 3 that says, and the authority must give reasons in such and such circumstances, the obligation to give reasons is that set out in the statutory provision.
Yes.
As we've seen from that passage, there is, of course, the obligation to provide reasons for a review decision, but the reasons required to be given depend on the issues on the review, and the agenda for the review is set by the issues raised by the applicant in the representations on the review, or where the issues are obvious. And the authority for that, again, is going back to Crane. And it's page 39 of the bundle. And it's paragraph 14. And the court there refers to the review procedure giving the applicant or another person on his behalf the opportunity of making representations about the elements of the original decision that dissatisfy them. And of course they may suggest further inquiries. The review is as the appropriate word for the act of submitting for examination and revision an inquisitorial administrative decision affecting the applicant's most basic social requirements. Given the full-scale nature of the review, a court whose powers are limited to considering points of law should now be even more hesitant than the High Court was encouraged to be at the time of the early case of Ex parte Behind, if the appellant's ground of appeal relates to a matter which the review officer was never invited to consider and which was not an obvious matter he should have considered. Again, that's qualified in cases of disability by the case of Peretti. But applying those general principles, no obligation to provide reasons in relation to Article 3 and the requirements being met in an offer letter. We get that from Alabicki. There may be an obligation to provide reasons in relation to Article 3 on review, but I say that's only to the extent that the issue has been raised by a positive case being raised by the applicant to suggest that the particular requirement is not met. And I use the word suggest there deliberately, because obviously an applicant who comes back from a viewing saying there was damp at the property raises a positive case that the reasonable physical condition requirement is not being met, even if they don't refer to Article 3 in particular. And we've seen in the Westminster, the Waltham Forest decision, that that's broadly what happened, and the review officer very properly treated that as raising a positive case to be considered under that first limb of Article 3, and the reviewing officer, Waltham Forest reviewing officer, then proceeded to address that case.
Well, I see that, but is either of these cases really about the duty to give reasons?
Well, it's put as my learned friend's submissions in his skeleton argument suggest that there's a duty to investigate and produce a reasoned decision in relation to each of the 10 requirements.
Well, he says there's a duty to investigate before the local authority can say that it's satisfied that the property is in a reasonable physical condition. And unless it has, he says, unless the council has evidence on which it can say it is satisfied that the property is in reasonable condition, it cannot lawfully approve the offer or make the offer with one strike and you're out condition attached. That seems to me, speaking for myself, to have nothing to do with the duty to give reasons.
That part of his argument has nothing to do with the duty to give reasons. It's about the duty to make inquiries. And on normal principles, that would depend on what information the authority had and whether any reasonable decision maker or authority would have made further inquiries in the particular circumstances of the case. And I say the duty to investigate depends on the particular circumstances of the case. And that is, as a matter of general law, the general obligation on an authority to make inquiries into suitability, which is primarily a matter for itself, but which the court can interfere with.
You're saying it's entirely lawful for the local authority to say, we will not inspect properties at all. We will not expect any inspection report to be sent to us. We can assume that St Mungo's is undoubtedly a fit and proper person, and we can proceed on the basis that unless there is specific cause for concern raised, the property is assumed to be in reasonable physical condition.
I say it all depends on the circumstances of the case. If the property is being provided by a new provider with no track record, or a provider with a dubious track record, or the applicant comes back and says it was damp, then there may well be a duty to investigate. And that in those circumstances it may well be that any reasonable authority would carry out that investigation. However, with an established provider who is, as I think St Mungo's put it, that Real Lettings was set up to provide high quality housing to homeless applicants, and they're putting this forward as accommodation which is suitable to be offered as, or fit to be offered as a private rented offer. With an established provider in those circumstances, it will be reasonable. I say, well, it may well be reasonable. It will depend on the circumstances of the case.
What circumstances does it depend on, apart from the fact that St Mungo's are an established and respectable landlord?
Well, that is the main circumstance. But it's not just that St Mungo's are a respected landlord. It's that St Mungo's are putting this forward as a private rented sector offer, and as a competent and respected landlord will be well aware of the obligations and the requirements that such accommodation is bound to meet, and indeed as a as a sensible landlord, will be well aware, or certainly ought to be aware, that unless provisions as to energy performance certificates and gas safety records are met, at the end of the 2-year assured short-hold tenancy, they may well find themselves unable to recover possession because there are bars on serving Section 21 notices and pursuing no fault eviction. In certain circumstances, if the statutory requirements as to gas safety and energy performance and as to licensing have not been complied with.
You mentioned that another factor was whether the tenant or prospective tenant comes back and says, I've been to the property, it's riddled with damp or whatever it may be, but surely that's too late. That's a separate point. By this time, the one strike and you're out offer has been made. And if the tenant does that, he's at risk of being told, well, that's it. You're out. We're evicting you from your present accommodation. You can try a review if you like, but you say that's perfectly all right.
Well, the tenant coming back is yes, you are of course right. That's not something that would arise before the offer is made and the viewing takes place. But it's an issue that would arise on review. And it would be open to the review of the reviewing officer if a positive case is made to say this accommodation was not in reasonable physical condition, then the reviewing officer will be bound to consider that positive case and reach a view. And if the appellant was right and it wasn't in reasonable physical condition and shouldn't have, and the reviewing officer reaches the view that it shouldn't have been considered suitable for that reason, then the appellant will succeed on their review and the duty will be reinstated. But the other point...
you can accept it. Sorry.
That was what I was about to say. The other point that could be made is it's that the review can be pursued whether or not the offer has been accepted. So the applicant doesn't have to turn down the accommodation and risk being left with nothing. They can accept the accommodation and request a review. And if the review goes in their favour, they'll be offered something else. If the review goes against them, they won't be offered anywhere else, but at least they won't lose their current accommodation.
Yes.
I don't know if I could add in relation to that, I'm sorry about that, but the legislation provides that the applicant must be told of that as a condition of the private rented sector offer. So they must be told that they can accept the offer and request a review. So when I take you to the offer letters, you will see that they include that warning very clearly.
Yes.
And indeed, what one sees from the history, we don't see this in the bundle, but I think it's in my learned friend's chronology. In this, Mr Hajjaj didn't attend the viewing on the 2nd of May, and he was given a further opportunity to view, and he did go and view a week later. He initially was inclined to accept it, but then decided to refuse it. So there was a process of dialogue, and he was given every opportunity to accept this. Of course, in his case, the reason he was unhappy with the offer and didn't want to accept it was because it was in Bexley rather than Westminster, and it was too far from his support. It was nothing at all to do with the condition of the property. So I say that what the law is that the authority has to make inquiries, and that's a matter for the authority, and the court can interfere on reasonable grounds, and there may well be some circumstances where if the authority hasn't made inquiries, then the court will be willing to interfere. But the fact that in some other circumstances where there's a long-standing arrangement with an established and trusted provider who can be assumed to get these things right, to have put things in proper condition before being offered to be let, a reasonable assumption can be made, and it's not unlawful for the authority in that decision, in that situation, to decide not to make those particular requirements. And if the assumptions prove to be mistaken and the applicant has accepted the accommodation, then they can, and they find that it's not in reasonable physical condition, or the electrics are problematic, or the landlord doesn't turn out to be a fit and proper person, then the applicant can make a further application to the authority saying, I'm statutory homeless because this accommodation is not reasonable for me to continue to occupy, because it's damp, the landlords are harassing me every week for the rent if it's an hour late.
You referred us to cramp, and that's concerned with the duty under section 184 to make such inquiries as are necessary. But the statutory provisions here are not concerned with the duty to make inquiries, are they?
No, they're not. And what I say about the statutory provisions, and I can come on to the language of the statutory provisions,
Yes.
is that they don't add anything to the general law. And my learned friend focuses on the opening words and the fact that if any of the 10 requirements or the 10 circumstances arise, the offer can't be approved as suitable. But as my Lord Justice Nugee observed, the way in which the order is drafted doesn't lend itself to the imposition of onerous and positive obligations. It could have been drafted in a way that said the authority must be satisfied that the following things are the case. But it's been drafted so that the accommodation, for the first 5 subparagraphs, the accommodation is to be regarded as unsuitable if the authority is of the view that certain matters are the case. So taking Article 3.1a as an example, accommodation is not to be regarded as suitable where the authority is of the view that the accommodation is not in a reasonable physical condition. The authority which has an entirely blank slate and has no information whatsoever as to the condition of the accommodation won't be of the view that the accommodation is not in a reasonable physical condition, with the result that Article 3.1a won't apply and Article 3 won't prevent the authority regarding the accommodation as suitable. Now, of course, that then brings us back to the scope of the inquiries. The authority that has a completely blank slate may well find it said that no reasonable authority would have acted in that way, and any reasonable authority would have made certain inquiries. But that brings me back to the point that the necessary inquiries will depend on the circumstances of the case and whether it's an established provider making accommodation available for use as a private rented sector offer, or whether it's a new provider with no track record or a known provider with a problematic record.
How does that fit with the statutory obligation in section 193 not to approve an offer unless the local authority is satisfied that it is suitable? That's a positive. It has to come to the conclusion that the property is suitable. We know that one of the considerations under Article 3 is the physical state of the property. If the local authority has literally no information about the physical state of the property, how can it be satisfied the property is suitable or not. The true position is it simply doesn't know.
Well, it will all depend on the circumstances. It may well be, the authority may well form the view, or the authority may well form the view that there are no concerns, there's nothing to concern it in relation to the physical condition of the property. It's what prevents it being regarded as suitable is if there's something to concern it about the physical condition of the property. And it may reasonably form that view on the basis that it's dealing with a trusted and established provider who it may be entitled to assume the provider would not be making the accommodation available if it wasn't in reasonable physical condition and if it didn't meet the other requirements of Article 3.
But this is the mirror image of the point you make about the rather odd negative wording of Article 3 of the 2012 order. Going to the primary statute, 193 bracket 7F, it doesn't say the local housing authority shall not approve a private rented sector offer if there is cause for concern that the property is not in a reasonable physical condition, etc. It says shall not approve unless they are satisfied that the accommodation is suitable.
Yeah, that's certainly right, my lord, and it does have to be satisfied that it's suitable. But the way in which and Article 2 tells us that various things that need to be considered in considering suitability, and it's not expressed in a negative way. It's a positive obligation to consider particular things. So, and those were the things that we saw being considered in the suitability assessment. So it's about disruption to the working life of the applicant or members of their family, disruption to the education, disruption to medical treatment, and disruption to caring responsibilities.
Sorry, just to pause to make sure I understood what you're saying. I think you may be saying that the regulations effectively set out the whole field of what you have to think about in suitability terms. In other words, there's certain positive obligations in Article 2 and then negative ones in Article 3. But that's not quite what the primary legislation says, is it?
I'm not saying that it sets out the whole field, because all of the circumstances are relevant, and you may well get. So, for example, something that's not covered, I think, by the order, but would undoubtedly be relevant, is if a member of the household is a wheelchair user, you're going to need a accommodation that's suitable for a wheelchair user. But what the 2012 order points the authority towards doing is that in Article 2, this is page 207 of the bundle, there's a list of things that the authority must take into account, the location of your accommodation, including and then disruption to various things, and then the proximity and accessibility of the accommodation to local services, amenities, and transport. So there are things there that the authority must take into account. And then in Article 3, the way Article 3 is drafted is the accommodation should not be regarded as suitable where one or more of the following apply. So it's Article 3 sets out what might be described as 10 red flags, and if any of the red flags are there, the accommodation can't be provided, can't be regarded as suitable. And the real question is, or in the circumstances of a particular case, what would any reasonable authority have done to inform itself about whether or not those red flags are there? And in my submission, that must depend on the circumstances of the particular case, and must depend on things such as the nature of the provider and the track record of the provider, and so on.
Can I just sort of drill down below that, because as Mr. Colville said, the various subparagraphs are not all drafted in the same way. So A to E is a question whether a local authority is of the view that. But F, G, H and I, as he said, are drafted on the basis of whether there is a licence or a certificate. They're just questions of fact.
Yes, that's right, my
Now, if a local authority is in a position where if a certificate is missing, the accommodation shall not be regarded as suitable, it surely has to ask whether the certificate is in existence or not. You can't just assume the certificate's in existence, can it?
Well, in my submission, it can in suitable circumstances. If it knows that this provider provides private rented sector accommodation, it's always in good condition. The certificates have always been provided in the past. It uses a standard form tenancy agreement, which has been considered adequate. Then it may well be reasonable to make that assumption.
But how can you say that the reasonable physical condition provision is analogous to the tenancy agreement? I mean, you may have detected from my points I put to Mr. Colville, my present view is that in the case of a tenancy agreement with an established landlord, it may be perfectly reasonable to assume that it will be in the standard form which has been used in 1,000 previous cases. But how can you assume that all properties owned by a particular landlord will be in a reasonable physical condition?
Well, what one can assume is that the landlord is making this available as a vacant property which is ready to be let as a private rented sector offer, pursuant to a private rented sector offer. The landlord will be aware of the statutory requirements, will have carried out a void process between the previous occupant moving out and the property being made available for a new occupant to move in, whereby some check will be made as to its condition, and any problems that are identified that have been left by the outgoing occupant will be put right. And if the authority is dealing with an established provider whom it knows and feels confident will have undertaken that process adequately and competently, then in my submission, in those circumstances, it may well be reasonable for it to assume that that is what's happened. But it all depends on the circumstances of the particular case. And my learned friend says, well, the trouble with this construction is it means that local authorities can shut their eyes and avoid finding out any information about the property, and landlords will avoid giving it to them, and applicants will end up in substandard accommodation. But I say that's misconceived, because authorities have to act in a way that's reasonable, and if they act in a way that's Wednesbury unreasonable, then the court will intervene, and the authority that deliberately shuts its eyes in the hope of being able to offer substandard accommodation to an applicant is going to find the court consider that it's acting Wednesbury unreasonably. The authority which doesn't carry out any investigations with an entirely new provider with no track record whatsoever is likely to find the court intervening. And so my submissions in my submission don't leave open the legislation to abuse, because everything depends on the circumstances of the case. If the authorities acted unreasonably, Wednesbury unreasonably, the court can intervene. if it hasn't, then that's a matter for the authority, and the applicant is sufficiently protected. My learned friend in his, sorry, I should also say that isn't an approach. The appellant suggests that shifts the burden onto the applicant to demonstrate or suggest that the circumstances in one or more of the subparagraphs of Article 3.1 apply. In my submission, the approach does no such thing. Again, the scope of any necessary inquiries will depend on the circumstances of the case. Part of those circumstances, when the matter is being considered on review, may well be any concerns raised by the applicant, but that doesn't mean that the burden is being shifted back to the applicant. That approach is also consistent with the Code of Guidance. The Code recognises that accommodation might be inspected by someone on behalf of the authority, and it doesn't preclude the inspection being carried out by a trusted provider itself on the authority's behalf in appropriate circumstances. And I think my learned friend was inclined to accept that, but he said that nevertheless the inspection report would have to be provided for the review, for the authority's consideration. In my submission, that again will be dependent on the circumstances and whether the assumptions made by the authority were reasonable.
What do you say about the statutory obligation to have regard to the Code of Guidance?
The obligation is to have regard to the Code of Guidance, not to follow it. My Lord Justice Nugee asked to what extent the Code can be taken into account as for the construction of Article 3. In my submission, it can't. The question of construction of Article 3 is for the court. The Code of Guidance represents the Secretary of State's view as to the meaning of the legislation. The Secretary of State sometimes doesn't get it right. If the Secretary of State hasn't got it right, then that doesn't affect the construction of the legislation. I'm not suggesting the Secretary of State has got it wrong. I think suggesting that the accommodation is inspected by someone, either the authority or someone on behalf of the authority, is plainly sensible guidance. What I say is it doesn't preclude the inspection being carried out by a trusted provider in itself in appropriate circumstances.
But in this case, there was no inspection at all, was there?
Well, there was no inspection report provided to the authority. That doesn't mean to say there wasn't an inspection report. And indeed there hadn't been an inspection.
We just don't know.
Well, there was no evidence. I could tell the court that there was no evidence in relation to that before the local court.
It's one thing for a local authority to say, I'm going to rely on St Mungo's to inspect property, and I want them to tell me, either on each occasion or as a general matter of policy, that it won't let a property until it has inspected and satisfied itself that it's in good physical condition. But we don't even have that in this case. All we appear to have is the local authority assuming that because St Mungo's are good landlords, they would have inspected, not actually being satisfied that they have inspected. Is that fair?
Well, I think it's an assumption based on the arrangements. The offer letter refers to arrangements, and there may well be written arrangements between St Mungo's and the council. They weren't before the lower court, but unsurprisingly, they weren't saved on St part of the material that the reviewing officer would have considered when she picked up the housing file. There may well be such arrangements between St Mungo's and Westminster which specify these particular matters. But as I say, they weren't before the lower court and they weren't on the housing file.
Well, I can see that you might, because the statute does refer to making arrangements with private sector landlords. You might have quite detailed service requirements with someone like St Mungo's saying, on each occasion on which there is an offer made to us, you will certify that you have inspected and satisfied yourself that the electrics are in good order and so on. But we have to proceed on the basis that there was none of that, because there's none of that before us. And as you say, that's not the basis on which the reviewing officer proceeded. The reviewing officer didn't say, here's a service level agreement, and so I can assume that. The reviewing officer just seems to have assumed it on the basis of no material at all.
Well, the reviewing officer had what was said in the offer letter. So she knew that that Ms Noel, who'd written the offer letter, had made particular assumptions. She knew who the landlord was. She knew what the offer letter said about there being an arrangement with St Mungo's. She had the detail about St Mungo's that's given in the detail of the property from real lettings, that they were formed to help secure quality accommodation and that they're an accredited landlord. So and she had the limited details of the accommodation that's given in that document. So she had a limited amount of material, and in my submission that was sufficient for her to make the assumptions that she did. And indeed, the appellant's case, as I understand it, is not that the assumptions that were made by the decision makers were irrational or went to be unreasonable. Rather, the appellant's case is that it's impermissible to make assumptions at all. And in my submission, that cannot be right, and that there must be circumstances in which it is permissible to make assumptions. And it will all depend on the circumstances of the case and whether any reasonable authority would have made further inquiries in those particular circumstances.
If we look at the offer letter at page, starting at 85, would you accept that the statement at the top of 86, line 4, we believe in our view, this accommodation is in reasonable condition? That is simply the assumption. That there's no underlying evidence except the respectability of St Mungo's.
Yes, it was an assumption. Yes.
Right.
I think those are my submissions on Article 3.
Yes.
Anything else I can help?
You're going to hand over to your junior, Mr Grundy, at this point.
my learned senior.
Can I just check before we sit down? If we were persuaded by the appellant to allow the appeal, what would happen in practice? We'll quash the decision of the reviewing officer, and then what?
The reviewing officer would go away and consider the matter. She would see what evidence St Mungo's had in relation to the condition of the property at the time. She would see if they had the electrical safety certificate and so on and so forth. And if satisfied by that material, would make a further decision as to the suitability of the property.
So go back to revisit the suitability of this particular property, which was offered in 2020, and is presumably no longer available for Mr Hajjaj. I mean, if she came to the conclusion that it had been suitable after all, then he would have rejected an offer of a suitable property, and the homelessness duty would have been discharged. Is that right?
Yes, that's right. But if she comes to the conclusion that it wasn't suitable, the duty won't have been properly discharged, and it will be reinstated, and there will be a continuing duty to accommodation.
And if the homelessness duty is discharged, what happens to Mr Hajjaj and his family? Are they still in temporary accommodation?
As I understand it, he is, and in normal circumstances, he might not be, but because of the abnormal circumstances of the pandemic and accommodation being continued for people even after duties end in the circumstances of the pandemic, as I understand it, he is still in temporary accommodation.
But if the duty has been discharged and you don't owe him any duty at all, then you bring to an end his temporary accommodation in normal circumstances.
Yes, and he could then, in those circumstances, as someone with a small child, he could seek the assistance of children's services, who would, at the very least, provide accommodation, would need to take steps to ensure that the child is safeguarded, and that those steps might include the provision of accommodation to the family to ensure that the child was safeguarded in that way.
Surely, if the appeal were allowed on the basis that the reviewing decision, the reviewing officer's decision was unlawful, because, as Mr. Colville argues, the offer was not a valid offer because the authority had no basis on which to approve it, then surely the consequence would be that the decision that of the reviewing officer that Westminster no longer owed Mr Hajjaj the main housing duty would be overturned.
Well, the relief sought on the appeal is the quashing of the review decision.
Yes.
It would that would leave in place the original decision, both the original offer of accommodation and the original decision that the housing duty had come to an end because that offer had been refused. There would be an outstanding request for a review, which had been made by Mr Hajjaj, and no lawful review decision would ever have been made. So the obligation on the authority in those circumstances would be to carry out a fresh review and to reach a fresh review decision. And that decision would have to consider both the suitability of the accommodation and whether or not the duty had come to an end.
But it would have to consider the validity of the offer then, in the light of the court's decision. Would it not?
Yes, it would.
Because presumably the review is of whether the offer was properly made.
Well, the review is whether the offer was an offer of suitable accommodation. And in my submission, it will be open to the reviewing officer. The reviewing officer would have to address the suitability of the accommodation for herself. And in what's a very long review decision, one can see that the reviewing officer did that, conscientiously addressing the suitability from the point of view of the caring requirements and so on. If the review decision was quashed because the court were to decide that Article 3 hadn't been properly considered, that would be other aspects of the case that she would need to consider as part of her review.
Seems to me it can't be right. I mean, if you're right, then the appeal is simply dismissed. The judge's decision stands, the review decision stands, and Mr Hajjaj is no longer owed the main duty. But if you're wrong on the basis that the original offer was not a valid PRSO because the necessary steps had not been taken before it was made. It can't be that it can now be taken, or the case can be revisited on the basis that now the authority or St Mungo's on their behalf can carry out an inspection and make a report. It's to turn the case on its head, isn't it?
The appeal is not against the appeal to the county court challenges the review decision.
Yes.
It doesn't challenge the offer letter. It doesn't. The argument.
But that is because it can only challenge the review decision.
Yes, and it may well be that the argument is that the review officer should have decided that the accommodation was unsuitable because when the offer was made, these things hadn't happened. But in my submission, it would be open to the reviewing officer to look at whether or not these things were in place. Was there a electrical performance certificate in place? Of course, I accept that St Mungo's can't be sent in to inspect it in 2021 and to inform the reviewing officer as to what the condition of the property was in 2019. But it may well be the case that St Mungo's carried out a contemporaneous inspection before making the property available to local authorities for use as a private rented sector offer. And it may well be that if the court were to allow the appeal, that what had gone wrong is St Mungo's had it all on file and didn't send it to the authority because the authority were content for St Mungo's to keep it on file and not to look at it itself.
But that would be looking back to the date of the original offer.
Yes.
And whether the paperwork actually existed.
Yes, and whether the paperwork existed at that time, and if it did, in my submission, it would be open to the reviewing officer to decide that actually none of those red flags in Article 3 were triggered, and on that basis, the accommodation should be considered suitable. But yes, that's something that would have to be considered as at the date the offer was made.
Yes, I think I picked up somewhere that there's a difference on that between rejected and accepted offers.
Yes, there is.
Yes.
If Mr Hajjaj had accepted this, then the suitability would fall to be considered as at the date of the review decision. So that, for example,
Yes, but he rejected it, so you consider suitability as at the date of the original offer. Thank you.
those are my submissions unless I can have the court further.
Thank you very much, Mr. Peacock. Mr. Grundy.
My lord, my lady, I am going to, if you don't mind, go over the Article 3 point because I'm slightly anxious about some of the things, that most recent exchange. So, excuse me. In order to get to the Article 3 point, I need to work backwards from here using the law and then come forwards again using the documents that we have. So I'm going to go back through the legislation showing how we come to be here, and then in our case, go through the documents to show you what was put in issue at each stage. Subject, I don't want to interpose on Westminster's case, but the point that if the local authority has to be satisfied that a property is suitable in order to make a offer and you find that that is the law and that satisfaction requires some sort of positive intent, positive determination as opposed to not a negative determination, if I can put it like that, your proposition might be right. But of course, in the Westminster case, it would be open to the reviewing officer to go back and look at what were the service arrangements between it and St Mungo's, and that hasn't happened. And the reason why I suspect that hasn't happened is because it wasn't put in issue. Although Mr Colville my own friend, took you to a request for review that says, oh, and we don't think Article 3 has been complied with, you might not think that that's sufficient in order to say, well, you've got to investigate and provide us with details of your service arrangement with St Mungo's. So how do we come to be here? Well, the appeal below was a Section 204 appeal, and that's pursuant to a statutory provision, and that's behind divider 10, and it's a page 200 in the bundle. It's 2041, and it's 2041A in both of these cases. If an applicant who has requested a review under Section 202 is dissatisfied with the decision on the review, he may appeal to the County Court on any point of law arising from the decision, or as the case may be, the original decision, and that's where the review decision hasn't been provided within the statutory time period. So the limit is a point of law arising from the decision, from the review decision. Now you'll see there it's a Section 202 review decision. So what does Section 202 say? Well, that's back at page 196. Section 202, an applicant has the right, I'm reading from subsection 1, my lord, my lady. An applicant has the right to request a review of any decision of a local housing authority as to his eligibility, B, any decision of the local authority as to what duty, if any, is owed to him. And in both of these cases, the local authority has issued a "we don't owe you any duty anymore" letter. But if you go over the page, you'll see subsection 202(1)(g), any decision of a local housing authority as to the suitability of accommodation offered to him by way of a private rented sector offer within the meaning of section 193. So you'll see there, the right to request a review includes a right to request a review of the suitability of accommodation offered by way of a private rented sector offer. And if you go down, follow your eyes down that page to subsection 1, capital A, the one that was also inserted by the Localism Act, an applicant who is offered accommodation as mentioned in subsection 193, subsection 5, subsection 7, or subsection 7AA, and you will recall that that expanded the right to make private rented sector offers as a discharge of the section 193 duty, may, subject to subsection 1F, or as the case may be, G, request a review of the suitability of the accommodation offered to him, whether or not he has accepted the offer. There was some time ago a rather unfortunate case where it was held that the right to review only applied if you'd refused the accommodation, so people who accepted the accommodation weren't entitled to say, I want a review of its suitability. So that's section 202.
Is the relevant one capital A or one capital B?
It's one capital A. Yeah, you're right, Molly.
That's because the cross-references to paragraph G, which you say is the relevant paragraph.
Yep.
G refers to a private accommodation offer, whereas what we were looking at before was a private sector rental offer.
Sorry.
Is private accommodation offer defined somewhere?
No, sorry, subsection 202G refers to a private rented sector offer.
Oh, I'm sorry.
Sorry, yeah. So what in the People's Republic of Wales, they didn't introduce the Localism Act, and so you're not entitled to make discharge duties that local authorities have with the same through the private sector to the same extent.
You were referring us 2 minutes ago to section 1, little h.
Yes.
Perhaps you meant to refer us to section 1, little g.
Sorry, I thought I had used 1G. I apologise. If I said 1H, that was wrong.
Okay, in which case it does go on to 1 capital A. Yes.
Yes.
Okay.
So we then come to the cases, the authorities, about what is the agenda on a review. And my learned friend, Mr Colville, on behalf of the appellants in both of these cases, relies on Peretti to say, well, everything's in issue again. But that isn't what Peretti says at all. So if you go back to the paragraph 32, which is at page 85 behind tab 4, my lord.
Right, well, we haven't looked at Peretti at all. So let's look at it now. You all know it by heart.
Yeah, I'm sorry, it's a
Page 82.
page 82 in the bundle of authorities, my lady.
Yes.
Thank you.
I'd assumed that everybody knew the dictum, obviously, because it's referred to as a well-known dictum, but I accept that outside of the housing sphere, it may not run off the tongue quite as easily. So in Cramp, what was being considered was section 49A of the Disability Discrimination Act, 1995, which has been replaced by section 149 of the Equality Act and was effectively a precursor to what's called the Public Sector Equality Duty. And we'll come to Cramp in a moment. 32, I'll read it. The judgment, this is the judgment of Lord Justice Wilson. It was in July 2005 that Lord Justice Brooke articulated his well-known dictum in the case of Cramp, set out in 21 above. It was in December 2006 that section 49A of the Disability Discrimination Act came into force. It follows from my conclusion that his dictum now requires qualification. In circumstances in which a reviewing officer under section 202, or indeed the decision maker under section 184, is not invited to consider an alleged disability, it would be wrong in the light of section 49A subsection 1 to say that he should consider disability only if it is obvious. On the contrary, he needs to have due regard to the need for him to take steps to take account of it. So the decision...
I'm so sorry, you were reading from page 82?
No.
85.
85, I'm sorry.
Apologise.
I'm behind you. Yes,
So, in short, the point is, this wider duty of inquiry on a section 202 review only applies where there appears that there may be a disability, even if the applicant who has requested a review has not raised it. But otherwise, it was held in Peretti that the more restricted requirement to make inquiries and to make decisions when a review is being carried out was still that was applied in Cramp. And that's set out in the most clearly in the head note, page 75, head note number 4.
Okay, so we're still in Peretti.
We're still in Peretti. Do you want me to read head note number 4, my lord, my lady?
Yes.
The principle stated by Lord Justice Brooke in Cramp v Hastings Borough Council and Phillips against Camden London Borough Council preceded section 49A of the Disability Discrimination Act 1995 and required qualification. Where an authority are not invited to consider an applicant's disability, it is wrong to say that they should only consider the issue of disability if it is obvious. Authorities are not, however, required in every case to make inquiries as to whether an applicant is disabled.
Yes, well, that's lifted straight from the Cramp, isn't it? Apart.
No, because Cramp predated the Disability Discrimination Act. And so what Cramp says is, and my learned friend Mr Peacock on behalf of Westminster City Council took you to it, it's paragraph 14.
So that's back on page 39.
That's back on page 39, my lady. So the point is this. Outside of issues of priority need and disability, the request for review and the things that are put in issue on the review set the agenda for the review.
So you say it's quite simple. Unless a point is raised in the application for the review, it can't be raised later. And that's
Yes.
the end of it.
Yes. And part of your discussions with my learned friend Mr Peacock on behalf of Westminster City Council arise because my learned friend Mr Colville has been permitted to bring issues that weren't raised with any specificity on the request for review. And certainly in relation to the case against my client, Article 3 wasn't mentioned at all. We accept that issues of
dampness were raised.
yeah,
that necessarily brings in question of reasonable physical condition.
Absolutely, but those were addressed in the review decision.
Yes.
But he now says, well, you haven't got a copy of the tenancy agreement. Well, that was never raised on the request for review.
That's why you didn't mention it.
Well,
you didn't mention it because you
absolutely
weren't considering it.
Absolutely. Because if you look at what was raised and the specificity with which it is responded to, you can see that this reviewing officer very much had regard to the challenges that were being made to the suitability. And so all of the other material is produced, and now you're asked to assume from an absence of evidence, or from the fact that there is in this case no evidence for us to show that there's a copy of the tenancy agreement, that there wasn't a copy of the tenancy agreement. Now the difficulty is that the local authority are not obliged to provide reasons when they make the offer. The only time they're obliged to provide reasons is when they do the review decision. So the inadequacy of the reasons that is now being relied upon is not something that was ever raised. And like Westminster City Council, in fact, I think maybe the relationship is even closer. The London Borough of Waltham Forest, you'll see from the review decision letter, sorry, the offer letter, and I'll take you to it, because we're going to work back the other way now. The offer letter is in the supplemental bundle at page 35. If you look at the second paragraph up from the bottom, Mears Housing Management, and when I take you to the papers, you'll see that they've all been filled in by Mears Housing Management, managing on behalf of More Homes WF. You might think that WF is a bit of a giveaway, given that Waltham Forest is the local authority in this case. This is a joint venture organisation between the London Borough of Waltham Forest and a company. We'll contact you within 2 working days to arrange a viewing appointment. They will let you view the property and arrange for you to sign the tenancy. If you turn over the page, paragraph 2, which is on page 37, a third of the way up. I have also considered whether the accommodation offered is in the view of the council in a reasonable condition and have used the guidance in part 2 of the Suitability of Accommodation England Order 2012 to help guide me on the suitability of the accommodation offered itself. Mears Housing Management, on behalf of More Homes WF, will provide you with copies, etc. So that reference to part 2 is clearly a reference to Article 3 because of what is then dealt with substantively in the paragraph. If you look over the page, across the bundle at page 36, paragraph 1 refers to the location requirements in part 1 of the 2012 order, which is clearly a reference to Article 2 of the 2012 order. Article 1 of the 2012 order has no substantive, makes no substantive provision. It just says this is an order that shall be cited as the 2012 order. So you can understand the person making the offer regards Article 2 of the 2012 order as that part that deals with suitability for the purposes of location, and Part 2 of it that deals with suitability for the purposes of, we'll call it condition, but it isn't just condition, my lord. My lady, Miss Justice Falk, raised the issue of suitability with my learned friend Mr Peacock, and isn't it quite a wide thing? So we're going to come to this. There's a tension in one of the aspects of suitability is affordability. There's another order, the 1996 order, which says that accommodation can only be suitable if it is affordable. Many, or the vast majority of homeless applicants are people who will be in receipt of benefits. Their rent is going to be paid by benefits. In the southeast, in the M25, finding enough suitable, affordable accommodation is it is impossible. And that is why there is this issue of out-of-area placements. And you'll see this when we go to Applicant and Nuzolomezo, is that the local housing authorities are having to perform their duties to find suitable accommodation in circumstances where there is no affordable or isn't sufficient affordable accommodation within their boroughs.
Is it just a London problem?
No. But it's very much focused on the conurbations, but on London
More so.
more so. So from my experience, local authorities are having to creep further and further away from London. So I know that Haringey, for example, were using Luton, and they've now had to go outside beyond Luton. In Applicant, the offers would be made in Aston and in Birmingham. So one of the issues in Applicant was, well, hang on a minute, why didn't you consider the Chilterns, which is closer geographically? You could go and live next door to the Camerons or something like that. And effectively, Lord Justice Lewison took judicial notice of the fact that the next place in which you're going to be able to find accommodation with sufficient transport links is another conurbation. This, as close as possible to the locality, means not as the crow flies, but
Yes.
transport links.
While we're on the offer letter, 25th of February,
My lord, yes.
it doesn't refer, unless I missed it, to the inspection report, but we do have an inspection report of the 31st of January at page 55.
We do.
Yeah.
So you'll recall, my lord, that there was no obligation in the offer letter to give reasons. We can assume that because the local authority is a member of the company who is offering the accommodation, and because they have a long working arrangement with Mears, that the documents that now appear in the bundle from page 55 were available. And if you turn to page 55, which is the inspection report.
Sorry, can I just clarify that? Were these documents not on?
They were on
possession of the housing file that
Yes.
was available to the review officer.
Yes.
Would these documents have been on that housing file?
Yes. I cannot tell you that they were on there when the offer was made, but the very strong assumption is that they were. And the reason I make that assumption is because you will see that the report is dated the 31st of January 2020,
Yes.
and the local authority for which the report was made is the London Borough of Waltham Forest.
Yes.
You also said that Waltham Forest was a member of the company making
Yeah.
the offer. Is that something that's in evidence? Is it?
No, it isn't.
It's on instructions.
It's on instructions, yeah. sorry, I just for reinforcing the point in relation to the limits of this court's power under Section 204, if I could just take you to the Rother District Council and Freeman Roach decision, which is behind divider 7 of your authorities bundle, and it's paragraph 31. I think that's the decision of Miss Justice Rose.
Sorry, can you give us a page number?
I can. It's I apologise. 135. The report starts at page 121, my lady, and the paragraph 31 is at page 135.
And whose judgment is that, do you think?
It's Miss Justice Rose, who was sitting up, as it were. There are decisions which approve Miss Justice Rose more than just they confirm her by Lord
Justice.
Justice.
It must be Lady Rose actually now is not Sir Christopher Rose who was a long way back.
Lady Rose.
Sure.
Yes, she's been at the time. Paragraph 31. When an applicant appeals a review decision to the county court, the relevant counsel is not required to establish that the review officer applied the correct test. Rather, it is for the applicant to show that the decision letter contains an error of law. In my judgment, there is no error of law apparent in Mr. Bolton's decision. If one reads the review decision as a whole, there is no basis for concluding that Mr. Bolton applied the wrong comparator. Mr. Bolton correctly states that the HOTAC test, when he says that a person is vulnerable. What I take from that is, what extent is the burden on the local authority when it's carrying out a review to show that all of the necessary provisions have been complied with, or the extent to which the applicant has to show that they haven't been? And I say, well, it's pretty strong support for the proposition that it is for the applicant to show the error, not for the local authority to show no error. So in the legislation, we've come back to section 202. I did just want to take you to section 184, if I may. And that's at page 187 in the bundle behind divider 10. My learned friend Mr. Peacock took you through section 184 1A, so I won't repeat it. What I was simply going to say is you'll see there that under subsection 1B, the local authority has to decide what duty, if any, is owed to a person. And I just wanted to set out what some of the criteria are in relation to that. So the principal decisions are whether somebody is homeless or threatened with homelessness. Because if they aren't homeless or threatened with homelessness, the duties don't arise. The local authority, where they find that somebody is homeless, they have to decide whether or not they are intentionally homeless. And where they are intentionally homeless, a lower duty is owed to them than if they are not intentionally homeless. So it's been described to me as the deserving poor get housed, not the undeserving poor. A slightly unfortunate way of putting it. But if you go to section 193, you'll see that duty only arises where somebody is homeless but not intentionally homeless. And then the last issue that local authorities have to consider is whether or not somebody has a priority need for housing. So you will have seen cases where what is an issue is whether or not somebody has priority need, and priority need could be described as, or could be classified as, a vulnerability, but unfortunately vulnerability is one of the criteria on which somebody can have a priority need. But it means people who have a greater need for housing than the general population. So as a single male, it's unlikely that I'm going to be somebody who has priority need. The categories of priority need are pregnant people, people with dependent children, people who are vulnerable as a result of a health issue or age, and people who are fleeing domestic violence has been introduced, people are fleeing, are homeless, as a result of domestic abuse, is another category that's been introduced. So you can see that the idea of the Act is to provide accommodation for those who are most desperately in need of it in circumstances in which they haven't caused their own homelessness. So then, if we just go to the section 193 duty, there was just one thing I wanted to pull out from this, my lords, my lady. And it's to do, this will arise in relation to the section 208, the first ground of appeal against the London Borough of Waltham Forest. Under subsection 2, so section 193 establishes a duty to secure that suitable accommodation is available for occupation by the applicant, and that's a continuing duty until the duty ends.
1932 doesn't say suitable. Suitable comes in later.
All accommodation that's provided under Part 7 of the Housing Act 1996 has to be suitable. Yeah. Suitability may depend upon the period of time for which it's expected to be provided. So Diogenes' barrel is okay if it's just for a night, but after that you have to do a bit better than that and have a Premier Inn. And then depending upon the length of time. There are a number of ways in which the duty ceases, but all of them relate to, there are two categories. One is that somebody ceases to occupy suitable accommodation as a result of their own action. So they make themselves effectively homeless intentionally. And then the other is that if they are made an offer of what is more permanent accommodation. So local authorities have to consider, when they're providing people with accommodation, they have an initial duty to provide them with accommodation, which will for these purposes called temporary accommodation, which is the accommodation that they're providing under section 193 subsection 2. And then they have a duty to provide more permanent accommodation, they don't have a duty. The way in which they can absolve themselves of the section 193 duty, or cause it to cease, is by making an offer of something that is more permanent. And that might be from the private sector. Of course, most applicants hope that it's going to be an offer of social housing, but it doesn't have to be in order to cause the section 193 duty to cease.
In principle, it would cease then. If they were offered suitable private rented housing, it would cease until, for example, that letting comes to an end or becomes unsuitable.
So that is complicated because the point about the private rented sector's offers is they have to be for a minimum period of time.
Yes. So
it may very well be that when somebody ceases to occupy that accommodation, they can make an application back to the authority that placed them there. Or alternatively, they can make applications to other authorities in which the accommodation was situated. The Nozolomezo case is a case concerning temporary accommodation, not an offer that caused the section 193 duty to cease. So we've had a look at the offer letter. And we've assumed, for these purposes, that all of the certification that was pulled out by the reviewing officer was on the file for the officer who made the offer. My learned friend, Mr. Colville, has taken you to the email request for review, dated the 28th of February. The local authority then issued what's called a minded to letter. So if you turn to page 16 in the supplemental bundle, my lord and lady. you'll see there it's headed in bold at the top, minded to letter review decision under section 202, as amended by the Act, etc. A minded to letter is sent, if you look at paragraph 4, it's sent under Regulation 7 of the Homelessness Review Procedure, etc., Regulations 2018. Those regulations say that if the reviewing officer is minded to find against the applicant, but for reasons that are but they're of the view that there may have been an error in the offer letter, the applicant should be given another opportunity to make representations. And so this brings us back to the procedural fairness point, because the first time that the applicant is, or the first time that the local authority is obliged to provide reasons is on the review, you can see that if the review is going to find against them but on a different basis, the applicant has had no opportunity to make representations in relation to that decision. It isn't suggested in this case that there is any failing or fault with the minded to letter. And if you turn on to page 22, you'll see that there's a heading grounds for review, and it's set out the basis upon which it was being suggested that the property was unsuitable. A lot of the minded to letter finds its way into the relevant parts of the final decision letter. So in his chronology, my learned friend left the minded to letter out. So if you look at page 31 on the minded to letter, one of the requirements of a minded to letter is to give the applicant an opportunity to make further written submissions in response to the minded to letter and the basis upon which the decision is about to be made. You'll see there, last two paragraphs of 31 gave Miss Akhter an opportunity to make submissions by the 31st of July. If you turn on to page 4, my lords, my lady, those are the representations made by lawyers, made by a solicitor on behalf of Miss Akhter. They carry on to page 15, so they're 12 pages long. You'll see that under the heading on page 5, there is some reference to legislation. You'll see there's no reference, although there's a reference to Article 2 of the 2012 order on page 6. There's no reference to Article 3. And you then get, my lords, my lady, the review decision at page 116 in response to that in the main bundle at page 116 through to 143.
Yes.
Is there anything in the solicitor's letter and revisiting the question of dampness and physical condition? which had been raised in the original email.
I don't think. My Lord, no.
Is it your submission, when considering at the further stage, you have the initial review, you have the minded to letter,
Yes.
you then have representations, you then have the final review decision. Is the officer, when making the final review decision, limited? Is he obliged only to consider the matters in the further representations, or does he have to go back to the original?
Well, in my submission, it's probably more complex than that. On the basis that Miss Akhter wasn't represented when she sent her first email, I think that, and she had inspected the premises, I think that a reasonable officer would take account of what she said as a result of her inspection, as well as the more technical things raised by the reviewed letter. There is authority to say a generous appreciation should be given to requests for review when written by an applicant in person. And I would accept that.
Yes, that makes sense.
So the criticisms that are made by my learned friend under Article 3 in the Akhter and Waltham Forest case is that there was no carbon monoxide assessment. The local authority didn't say there's no risk. We're satisfied that the precautions taken by the landlord for the purposes of reducing carbon monoxide poisoning are satisfactory. The property is electrically heated. The local authority cannot rely on repairing obligations in tenancy agreements. So, in my submission, the Article 3 does not say that the property must be free from defects. What it says is that the local authority must be satisfied that it's in a reasonable condition. What did the local authority have before it? It had the sign-off form completed by Mears Housing Management. And at page 57, you'll see it says, at the top of the page, this is actually in the supplemental bundle, I apologise, we MHA surveyors are hereby certify that in accordance with the terms of engagement, the works identified in the report dated the 8th of May 2019 have been completed and the property is ready for occupation. Was that a basis upon which a reasonable authority could be satisfied that the property was in reasonable condition for letting? So it actually goes further than that, because you'll see on page 52 the email exchange at the bottom of page 52, 21st of February 2020. The substantive bit is at the bottom. Email, hi Dave, the PM who was handling the sign-up states there are no works required for the property. The issue regarding no water was due to the stopcock being turned off, hence the tap was not working. Also, someone used the toilet and there was no water to flush, but this has been rectified by turning on the stop clock back on. But tenancies use size of room as an excuse and distance from property from London. I hope this has cleared up any repair queries. So the fact of the stop clocks being turned off was confirmed.
Who is this from, just as far as we know?
It's an internal email.
Within the local
And
authority, not from
PM stands for property manager.
Yes.
So then, the last element, the last criticism is there's no copy of the tenancy agreement.
Well, before you leave the condition of the property,
Well, yes.
the email from the applicant said it was done.
Yes.
And the reviewing officer says, well, I'm not satisfied that it was a problem. It might have been condensation.
Yes.
Is that a question of fact? Is it a question of law? Is it, how do you characterise that?
Well, so what documents do we have upon which the reviewing officer could have found that she didn't think the property was done? We know that there's electrical heating in the property. And we know that from the inspection report and the EIC certificate at page 58. We also know that the property is reasonably well insulated because there's a copy of the EPC certificate at page 105. In my submission, the reviewing officer was entitled to rely upon what she had been told, or what the London Borough of Waltham Forest had been told by the professionals, MERS surveyors, that the works have been completed and the property is now ready for occupation. Acting on behalf of a landlord who is a joint venture company with the local authority. I think it is.
Sorry, just go back to the email on page 52. Again, is that part of the housing file that the
Yes.
review officer sees? The reference to the PM property manager says there are no work required.
Yes. So, paragraph 111 of the review decision where the reviewing officer has said the repairs will be carried out, she refers to those as minor disrepair issues. Article 3 does not say property cannot be suitable or in a reasonable condition if there is a minor disrepair issue. And in my submission, the local authority is entitled to take account of the fact that the landlord is indicating that matters would be repaired And then in relation to the damp, paragraph 113, in my submission, that is a finding of fact that was open to the review officer on the basis of all the other information that was in front of her, which is the sign-off that all the appropriate works have been completed, that there was an electrical certificate, and that there was an EPC certificate. So the property had electrical heating, and the EPC certificate indicated what the cost of that electrical heating would be, presumably to heat the house to an appropriate level.
Does it matter that the interval between the Mayor's sign-off and this review letter was 8.5 months?
So that was yes. Where an applicant rejects an offer, the review is carried out at the date of the rejection.
And in both these cases,
They rejected them.
they were rejected.
Yeah. I mean, they were warned.
What is said at paragraphs 111 following the final review decision is a finding not as to what the position is now, but as to what the position was
When the offer was made.
The offer was made or
And refused.
Query rejected
Yeah.
in February.
Yeah.
February. Yes.
So I did say, my lady, that I would show you the warning that appears in the offer letters. So if you turn to
I've
page...
seen it. The offer letters in both cases have the statutory warnings.
Yeah.
I don't think that's been.
You're warned to, you're advised strongly to accept this and request a review.
Yes.
In relation to the tenancy agreement, it was never put in issue. We know that Miss Akhter was to be shown the tenancy agreement and invited to sign it at the sign-up. Because in the offer letter, in the penultimate paragraph on the first page, it says, here, Mears Housing Management will let you view the property and arrange for you to sign the tenancy. It isn't surprising that the review officer doesn't say, we had a copy of the tenancy on file, or we have an arrangement with Mears whereby there's a standard form tenancy agreement, which my learned friend's position was rather equivocal. At some points he was saying, yes, I accept that if they have an arrangement with somebody, that's enough. And then at other points he was saying, no, the local authority must go and inspect. I'm not sure he really knew what his position was in that respect. But if it's right that it's okay for there to be a standard form tenancy agreement, which the local authority have agreed in an arrangement with itself as a joint venture company and Mears, then in my submission, the court could assume that the local authority was satisfied that the tenancy agreement was one that didn't include any unreasonable terms. But my learned friend cannot appeal on that point because it wasn't put in issue by the review or by the request for review. And my lords, that is one of my anxieties about the way in which this appeal has been approached by my learned friend, without taking you to the statutory provisions that bring us here. So I'm aware of the time. Do you want me to? Those are my submissions on the Waltham Forest case in relation to the Article 3 point.
That leaves the procurement point.
It does.
Do you want to add anything on what we ought to do, where the parties are left if we were to allow the appeal on the Article 3 point?
Well, I would submit in the Waltham Forest case, if you say the local authority has to have been satisfied at the time that it made the offer that the tenancy agreement was sufficient, in my submission, the offer letter clearly states that the local authority is satisfied that all of the Article 3 requirements are met.
Sorry, that's the provision you referred us to earlier on page 37.
That's right.
And your point is that doesn't need to give any reasons.
No. So you might say, well, the reviewing officer should pull out the provider arrangement that you have with Mears to see a copy of the pro forma tenancy agreement and say, yes, that's fine.
Thank you.
Yep. So the section 208 point. My learned friend makes a bold submission that unless a local authority has a procurement policy, it's breaching section 208. In Applicant, behind divider 8, a case which I did on behalf of the London Borough of Brent, the London Borough of Brent did not have a procurement policy. The decision in that case was upheld. I think that's binding authority.
Oh, not for the first time today. I'm saying you all know these cases.
I apologise. Divider 8.
Very often, at least one of you has been in them, but
Is that the one where Baroness Hale said?
No, that's Nozola Meso. We'll come back to Nozola Meso in a moment once we've gone through Applicant.
Could you give us a page?
I could, certainly. It's page 142. Can I just, before you find it, let me just give you the chronology. Nozola Meso was decided before Applicant. Nozola Meso was a case about temporary accommodation, and Westminster were providing people with temporary accommodation outside Westminster. Because the problem that I described to you about affordability in Westminster, that's magnified.
Yes.
Even more than it is in the London Borough of Waltham Forest. So finding suitable accommodation on the affordability aspect for applicants to London Borough of Westminster is very difficult within borough.
Even on a temporary basis.
Even on a temporary basis. So Nozola Meso was decided first and got all the way to the Supreme Court, and was about how high, what is the level of the duty under section 208. So in that case, we can go to it. It makes sense probably to go to it first because if that's behind divider 6, my lords, and at page 110, you'll see the extract from the decision, the review decision letter that was being challenged. As you are aware, Westminster is currently suffering from a severe shortage of both temporary and permanent accommodation. It is therefore not reasonably practical to offer temporary accommodation in the borough for everyone who applies for it, and therefore we have to offer some people temporary accommodation located outside Westminster. The Council's temporary letting teams carefully assesses each application based on the individual circumstances of each household member and decides what type of accommodation would be suitable for the household. Given the shortage of housing in Westminster and all of your circumstances, including those above, I believe that it was reasonable for the Council to offer your household this accommodation outside the Westminster area. It said nothing else about what was available in Westminster.
But at that stage, Westminster had no allocation policy, did they?
No.
They do now.
Yes.
We've seen it. Yes.
So the guidance that Baroness Hale gave, that my learned friend relies on at paragraphs 38, 39 and 40 of Nozola Meso, is obiter. And you'll note she says at paragraph 39, ideally each local authority should have and keep up to date. So she's not saying you must. And indeed, it wouldn't have been appropriate in that case to say that, because it wasn't an issue.
And why was it Akhter?
Because the decision is a reasons decision. What it found was that the local authority hadn't given a sufficient explanation as to why there was why they hadn't offered accommodation in borough, or what was available in borough, and why that had been offered to other people. Yeah, sorry, my learned friend, Mr. Peacock, very kindly has referred me to paragraph 42. No doubt there are other ways in which an authority could ensure that their decisions are properly evidenced and properly explained, but a standard paragraph of the sort that was used in this case is not one of them.
Well, boiling it down, all they said in this case was, we haven't got enough accommodation in borough, so we've sent you to Bletchley.
Yeah.
And if exactly the same facts arose now, they would say, we can only accommodate in borough people who are within band 1 or band A, whatever, the top grade, who are, and then it set them out, you're not within the top grade, therefore we can't accommodate you in borough. They might have to explain why it has to be as far as Bletchley, but
No.
that,
Can I say, in the current climate, you'd be lucky to get Bletchley.
yes, right. All right, do we need anything else from Nzolomezo?
No,
Alec Biet, then.
Applicant. Yeah. So just to confirm that Lord Justice Lewison took the view as well that Nzolomezo is a reasons decision. Paragraph 45 at page 157, my lords and my lady. In essence, therefore, this was a reasons challenge. Lady Hale recognised that housing authorities had a difficult task to perform and gave some helpful general guidance on what should be done in the future. I apologise, my lady. It's paragraph 45.
Yes.
So in Alib Kiet, the Brent London Borough Council didn't have a procurement policy, although it had an allocation policy. It set out what it was doing to procure accommodation in broad terms. It said, we don't have enough accommodation, we can't find enough affordable accommodation in our borough. We have 2 offices operating in the Birmingham area, 2 offices in the borough, and 1 in between. I might have got those details slightly wrong, but in effect, what they were doing to obtain property was set out in the review decision. So at paragraph 77 in Alib Kiet, Mr. Alib Kiet was represented by my friend Mr. Westgate QC, and he accepted that in Mr. Alib Kiet's case, Brent has provided adequate explanations to why there are a limited number of units available in London. He points out that nevertheless Brent acknowledges that units in London are procured, but he says Brent has not explained how those units are procured or the success that is achieved in obtaining them. Barely any information is given about the multiple viewings accommodation that is available to both Brent and other authorities. So that challenge was rejected. on the basis that the court took judicial notice, effectively, of the difficulty in finding suitable, on the basis of affordable, accommodation in London. Now, in this case, Miss Akhter was offered accommodation in Harlow, which was only half a mile from the temporary accommodation that she was in.
Are you suggesting that that makes a difference?
No. Well, the Article 2 of the 2012 order says that one of the factors that you have to take into account in deciding whether accommodation is suitable on the basis of location is its proximity to the previous accommodation occupied by the applicant.
Okay, so it is potentially relevant.
It's potentially relevant.
It's less attractive if that accommodation is temporary. And of course, if the tenant is somebody who'd lived in the same street for 15 or 20 years but has fallen on hard times and become homeless, you would say, well, it's not unreasonable to move half a mile away. But
no. I think that she'd been... Can I just get some...
Yeah.
My learned junior is just having a look. We think that Miss Akhter was in the temporary accommodation for between 12 and 6, a period between 12 and 6 months. It will actually be set out, I'm sure, in the review decision because it deals with the. If you look at page 117, my lords, my lady. Yeah, on the 3rd of July, paragraph 12 on page 117
of
on the 3rd of July 2019. Of the appeal bundle rather than the supplemental bundle, page 117. This is part of the review decision.
Temporary accommodation on 3rd of July.
Yeah, and you'll see the postcode CM21DR. The postcode for the instant accommodation is CM21JL. I had a look on Google Maps and they're about half a mile apart.
all right, back to Alec Beard. Anything else from that judgment?
Simply that it's, in my submission, binding authority for the proposition that the failure to have a procurement policy is not a slam dunk for Mr. Colville, my own friend. Because in that case, the failure to have a procurement policy did not result in the decision being quashed.
But Brent did have an allocation policy.
They did have an allocation policy.
And they gave some reasons why the applicant was not being accommodated in Brent.
Yes, so they went through the other accommodation that was available. So my learned friend took you to page 41 in the supplemental bundle.
Yep.
Unfortunately, looks like it was a computer printout that was on an A3 page. Because if you look at page 42, you'll see it has the same number of rows.
Yes.
And so the top row, room 433, Hungerdown Way, Chingford, was a studio, if you turn over the page.
Oh, I see.
And flat 1, Dennis Court, 148, Hainault Road, London, was a 2-bedroom flat. Now, my submission is that it would not assist Miss Akhter at all to know what procurement efforts the local authority are making, unless she is saying they're irrational. And we know that they can't be irrational because if we look at the number of accommodations that they have, they're 10 on the 25th, available for allocation on the 25th of February 2020, some in borough, some out of borough but close, and of a range of different sizes. The review letter.
How do we know which ones are in borough? E17, is it?
Yes, I did have a look at. I've set it out in my skeleton argument which ones of the postal boroughs, which postal areas are the London Borough. I think it was E11, E17, E18.
All right. Well, we don't necessarily have to go through each one.
We don't, because in fact the review.
Some clearly are CM20. One or two aren't. Anyway.
So if you turn to page 132, my lord, my lady.
Of the Corbin.
So it's page 132, my lord, my lady, paragraph 85. From 83. The review officer deals with the available properties.
Isn't that at the stage at which she's offered temporary accommodation?
No, this is the PRSO offer. Apologise, yes.
86. 3 temporary accommodations which are studios and unsuitable.
Yeah, no, I apologise. That was to do with. Sorry, if you look at the representations on the review, they raised the locality of the interim accommodation and not the locality of the.
I think it's raised in later paragraphs.
It is. I
91.
apologise. That's. Yes, it's paragraph 91. I apologise.
Yes.
Now, in my submission, that is also evidence not only of the application of the allocation policy, but also evidence of the matching exercise that my learned friend says there is no evidence of. So what do we know about Miss Akhter? We know that she needs what is colloquially called level entry accommodation. That means either from ground floor level or if there's a lift, any floor. And that she has a dependent child who lives with her and they need 2-bedroom accommodation. And then, my lord, my lady, the offer letter, sorry, the review letter, I apologise, goes on at paragraphs 94 and 95 to deal with the difficulty that the local authority has in procuring accommodation within its borough and the fact that it relies on accommodation that is further away and is relying more and more on private rented sector offers or accommodation.
Yes, well, we can read it, Mr. Grundy, but you say this isn't really a case about the presence or absence of a procurement policy.
No.
And the allocation of this particular property was for the reasons set out in this letter.
Absolutely. Yeah, so my Lords, my Ladies, those are my submissions on behalf of the London Borough of Waltham Forest in relation to both ground 2 at first and ground 1 subsequently.
Thank you very much.
My Lord, thank you.
Mr. Cohen.
My Lord, my lady, I take it my Lord wishes me to deal with the matter now, given the time.
I think so, unless, do you have any idea how long you would be?
I think I'll be probably about 10-15 minutes.
Please go ahead.
Thank you very much. My Lord, my Lady, the learned friend, Mr. Grundy, refers to Crump and submits that the scope of the review is limited by the representations on review, and in the absence of making the representation, any representation on review in respect of the issue raised in the appeal as to the legality of the decision, then that the authority can't be criticised for not having dealt with it because it wasn't raised in the representation on review. Firstly, in respect of the Mr Hajjaj, Article 3 was clearly raised. It was an issue that it was clearly put in the representation that Article 3 had not, there was no evidence to indicate that it had been satisfied. The issue was live for the reviewing officer to address, and she didn't address it, and therefore it was a matter that should have been dealt with. But the question is, did the reviewing officer in Waltham Forest have to deal with the Article 3, irrespective of the fact that it wasn't raised in its totality? It was raised by reference by the applicant herself when she's informed them that the property wasn't in a reasonable physical condition, and therefore that, in my submission, engages Article 3 in any event. But even if I'm wrong on that, the fact one has to step back and look at what is required when assessing suitability, and it's clear that under section subsection 7F that there is a positive duty on the authority to consider whether to approve the PRSO, and they cannot and shall not approve the PRSO unless they are satisfied that the accommodation is suitable, i.e. present. So the duty on the authority is to consider whether or not at that point of offer whether it is suitable, and they cannot approve it if it's not. That engages Article 3, because when we go through over to Article 3, it provides that the accommodation shall not be regarded as suitable. Now, you have my submissions on how that's to be construed, but the Article 3 is engaged and is by subsection 7F, and therefore there is a positive duty on the authority to make and to carry out that assessment, both in respect of the offer and in respect of the review that's been requested of the offer. They're going back to, as a result of section 202(1)(g), they've got to go back and look at the question of whether or not, at the date of the offer, the accommodation is suitable or was suitable at that date. Now, in the decision of the court, this court in Peretti, the court, which my learned friend took Your Lordship Lady to, that was a case where it involved discrimination or disability issues arising and the duty that arises under the public sector equality duty. And in paragraph, it's in paragraph 8 of Lord Justice Wilson's judgment, he sets out page 77. He sets out the provision of section 49A, now 149 of the Equality Act, and he sets out what the authority shall, in carrying out its functions, have due regard to, and then puts in italics, little d, the need to take steps to take account of the disabled person's disabilities. And by reason of that duty, positive duty, to take into account the disabled person's disabilities, it followed that CRAMP had to be revisited because of the positive duty to take into account the disability, even though it wasn't raised. It was clearly an issue that was on the papers. It was before the authority. They hadn't considered it. And what they, and in paragraph 32 at page 85, Lord Justice Wilson states, it follows from my conclusion that the dictum, reference back to Lord Justice Brooke in CRAMP, now requires clarification. The reviewing, in circumstances in which the reviewing officer is not invited to consider an alleged disability, it would be wrong, in light of the positive duty that is imposed by the public sector equality duty, to say that he should consider the disability only if it's obvious. On the contrary, he needs to have due regard to the need for him to take steps to take it into account. So he could not rely upon the general approach in CRAMP, saying, well, if it's not raised in the review, therefore it doesn't need to be considered. He had the authority, the reviewing officer, had erred in law in ignoring the effects of the positive duty imposed by the public sector equality duty. In my submission, the effect of subsection 7F and Article 3 is that it imposes a duty, positive duty, on the authority, and in particular the reviewing officer, when carrying out the review, to ensure that the property at the date of the offer was suitable and satisfied the requirements. And if it did not, then it cannot be a lawful discharge of duty. So to that extent, the learned friend, with great respect, submission cannot be right, and it cannot be right that that on review any applicant, any appellant, is unable to raise challenges where there's a failure to discharge the positive duty that is imposed by the Act. In respect of the following on from that submission, it's quite clear, given that there is a positive duty to assess suitability, it is not open to an authority to close its eyes, put its hands over its ears and say nothing by way of inquiries, and then assume that because of the nature of and the identity of an individual landlord, that they can make an assumption that all other matters in regards to the Article 3 requirements, that they are satisfied. We can see that, in particular, subparagraph J, that there is an obligation imposed on the authority to obtain a copy of the written tenancy agreement. The reason being is because if there is if the landlord has not provided the local authority with that tenancy proposed written tenancy agreement, it cannot be suitable. It's a matter of inevitable construction of the article. So the authority not only have to see the proposed written tenancy agreement, but they also have to consider it in order to determine whether or not it's, in their consideration, adequate. If it is considered to be adequate, well then that addresses the issue, but they have to take that positive action to deal with. If it's a case that the local authority are working with a long-standing partner, or indeed they are connected, as it would appear, Mears Homes WF, the Malone Friends submission on instruction, it's still, the reviewing officer in my submission has still got to ask the question, and in order to, and depending on the answer he gets, i.e., well, it's the same agreement that's always been used. If you want to see it, you can log on at such and such a place, or it's been approved by, and he can then assume that it is acceptable because it's been approved by whoever or wherever. He has to have a basis on which to reach the conclusion that the agreement is adequate. Silence cannot form the basis on which the assessment of adequacy is undertaken. In respect of the Akhtar's review and how that was dealt with by Waltham Forest, the Malone Friend took the court to the sign-off documentation, which starts at page 55 of the bundle, of supplementary bundle. That is on the 31st of January, saying that the works that have been identified have been completed. But the viewing of the property was on the 28th of February. So after the sign-off, at that we can see from her email, there was questions raised regarding the physical condition of the property. And it's right that there is the email from Malone Friend, says it's the property manager, where he says at page 52 that that there are no works required to the property, but there's been no investigation in respect of the physical condition, and in particular the dampness and the lack of heating. And we know from the now medical advice that the advice is that if that hasn't been addressed, the property wouldn't be considered to be suitable. But when we turn to the review decision, the officer states at paragraph 113 on page 137 that the property has been inspected, attached the certificates, and with the view that the wall marks in the kitchen are likely to be a sign of condensation. As I noted, you did not report signs of mildew, dark patches, discoloration, or the walls were wet when touched. Therefore, unlikely that there was damp in the property. But there's no basis for that for the officer to reach that finding of fact. One would expect there to be inquiries being made, given that the issue was raised, and we don't know on what basis it is that the officer has concluded that the dampness experienced was actually condensation. Malone Friends, well, it was open to the officer to reach the conclusion based upon the EPC and the electrical certificate, installation certificate, and so on. But in my submission, the report from the applicant as to the disrepair within the property cannot. It's not open to the authority to reach that conclusion and reject her submission, her finding that the property was in disrepair and suffered damp and was cold, particularly as this was a property that was empty and vacant. So condensation wouldn't be the issue. It is, in my submission, not open for an authority when faced with complaints of dampness and coldness within the property to say, well, those are matters that can be dealt with through the repairing obligations and could be resolved, and therefore you should accept them. In my submission, there needs to be a proper consideration of the Article 3(1)(a), which there wasn't. But in any event, in my submission, the authority are stuck with their failure to consider the tenancy agreement and little subparagraph J, and therefore, in line with the wording of Article 3, the decision is unlawful. So, too, the failure on the part of the authority for Westminster in that they have no evidence at all to support both the offer and indeed the review, which has assumed that there was compliance in the absence of any evidence whatsoever. My learned friend, in response to the questioning from the court, stated, well, the outcome of this decision, if the appeal were to be allowed, will be to quash the decision and remit back for a fresh determination. Well, Section 204, subsection 4, provides that the court on appeal has the power to vary the decision, and so it can vary in certain circumstances where the outcome is inevitable. That the decision is an imposed decision on the local authority, namely that the accommodation is not suitable, and therefore the duty is resurrected, and there's nothing further that the authority can do. That is a scope. That is a matter within the power of this court. Can I turn then just briefly on the procurement, Section 208 point? My learned friend took lordships to Applicant and the decision of this court in that decision and the judgment of Lord Justice Lewison, and in particular at paragraph 77, page 164. My lord, my lady, as I read and understand that judgment, the submission wasn't that the authority were acting unlawfully by not having a procurement policy. My understanding and reading of Lord Justice Lewison's judgment was that the decision letter contained sufficient explanation. But when my submission is, it is a bold submission, but it is a submission well made in my view, and that the procurement policy and an allocation policy relating to the provision of accommodation in discharge of the duty under Section 208, which is not limited just to temporary accommodation, in the case of Nuzolomesu, but it also applies in relation to the offer of accommodation under the private rented sector offer scheme. And given that there is that absence in my submission of a procurement policy, given that there should be a procurement policy, a local authority seeking to allocate it without clarity and explanation as to how they are seeking to procure the accommodation that they need, with both within and if not within where they seek to procure that to discharge their duties. My learned friend said, well, the situation is getting worse. People are no longer getting allocated accommodation even further afield than from the authorities in the London area that they're applying to. Well, that should all be made clear within the policy so that people who make applications and then are advised on their applications know full well how the authority are going to be discharging the duty if the duty is owed, and where they're likely to end up. And the absence of the procurement policy means it's not open to the authority's decision as to allocation isn't open to the scrutiny that is expected, and is, as a result, under Section 208, is not a proper discharge of that duty. Unless I can assist your lordships, my lady, any further.
Thank you very much, Mr. Kelville, and thanks to all of you. We will, of course, reserve judgment. You've given us much to think about. We'll let you have our decision on the 2 appeals as soon as we can, in the usual way, as everyone knows here, to be sent out in draft, not for re-argument, but for correction of typos and similar